The crime of second-degree murder requires malice aforethought. To have malice aforethought, must a defendant hate someone and plan ahead of time to harm that person? Or is it enough for a defendant to harm someone intentionally or recklessly in the moment? The California Court of Appeal answered this question in People v. Weisberg. Muriel Rita Weisberg was the primary caretaker for her two small children, a 2-year-old named Sharon and an infant named David. At 3 or 4 weeks old, David had bruises on his head. At 7 weeks old, David sustained 2 skull fractures, multiple broken ribs, and other injuries. David died from these injuries. Rita was charged with murdering David and tried in a bench trial. At trial, Rita claimed the head bruising and the fractures were all from David injuring himself in his crib. However, medical experts testified that around the time of the head bruising, David had also sustained a broken leg that couldn't have been self-inflicted, and that David's life-ending skull and rib fractures also couldn't have been self-inflicted. Thus, the medical experts concluded that both sets of injuries must have been caused by an external source. The state also presented evidence about Sharon. This evidence showed that Sharon was treated for a broken leg when she was 3 months old, and that she had an untreated fracture in her other leg at a different time. Like with David's injuries, Rita claimed Sharon had injured herself in her crib. But medical experts testified it was unlikely that these fractures had been self-inflicted. Other witnesses testified that Rita had openly neglected Sharon and had admitted to hitting and sedating Sharon. The court convicted Rita of second-degree murder, and she appealed to the California Court of Appeal.